centuries, state has resorted to force in their international relations in order to achieve particular desired aims. The use of violence has proved to be an accepted, although tragic in its consequence, method of resolving disputes between states. States reserve the right to wage war without any internationally agreed regulatory framework. Nevertheless, over time, the concept of just and unjust war has emerged. Hello everyone, I'm Farhana. Today in this video, we are going to discuss about the international regulation use of force. The use of force has been a long-standing phenomenon in international relations and has been considered to be directly linked to the sovereignty of the states. In the sovereign states have limitless power to use all impossible means to guard and protect their interests. However, the longer the period that has been associated with sovereignty of state, the more issue has turned into legal institution by itself. In the next part, we will discuss more about the prohibited and permissible use of force in international relations. But firstly, what is the definition of use of force in international law? In international community, force has been featured as a high level of decentralization. Force has been used for different purposes. It has been applied to previous intervention and to punish for non-compliance according to demand. War is the hardcore form of force and used to grab territories or completely suppress a state. War also has been considered to be permissible due to the existence of sovereignty among the states. In international law, there are two principles use of force. There are jus ad bellum and jus in bello. Jus ad bellum refers to the conditions under which states may resort to war to use of the armed force in general. Meanwhile, jus in bello or international humanitarian law is a law that governs the way which warfare is conducted. International humanitarian law is purely humanitarian, seeking for the limit suffering cause. These two terms will be discussed more in the next part.
For centuries, states used force in their international relations to achieve their aims. Although it caused tragic consequences, the use of violence was accepted as a method of resolving disputes between states. After the rise of independent states in Europe, the doctrine began to evolve. This approach was supported by the use of positivism, which focused on the idea of sovereignty and the Peace of Westphalia 1648. After World War I, efforts were made to rebuild international relations between states through establishments and operations of an international institution, so no aggression would occur again. Then, League of Nations was created in 1919. Under 1919 Covenant of the League of Nations, member states are required to submit any interstate disputes for arbitration or seek other forms of judicial settlement at League's Council. However, the Covenant wasn't succeed at revoking the right of states to resort to war. In 1928, another attempt was made in the form of General Treaty for Renunciation of War as an instrument of national policy, or more commonly called as KELLOGG-BRIAND PACT. However, the outbreak of World War II in 1939 marked the end of peaceful international relations. The tragic events of international conflict led to adoption of Charter of United Nations Charter in 1945, resulting in development of a framework aimed at regulating the use of force by members of international community.
Jus ad bellum, a title that defines the legitimate reasons engaged in war and focuses on certain criteria that allows a just war. It refers to the condition under which states may resort to war or to the use of armed force in general. It also governs the pre-engagement conduct of states and non-state actors that are considering whether to engage in war and armed conflict. It is concerned with the justification of and limits to the use of force.
Next, Article 2, Paragraph 4, Prohibition of Trade or Use of Force. This article prohibits the trade or use of force and calls on all members to respect the sovereignty, territorial integrity, and political independence of other states. Plus, the Security Council underlined the four principles of Article 2, which are reaffirming the prohibition of use of force, stating the importance of having good relations, calling for the cessation of support by the states to armed groups, and calling of parties to withdraw all military forces. However, there is an assumption in the use of force stated in Article 51, which is regarding the right of individual and collective self-defense, plus humanitarian intervention had claimed by some states. Self-defense. Self-defense is commonly any act in response to an imminent threat of death or great bodily harm to a person or property. The right is, however, not just limited to individuals and is also available to the states. The concept of self-defense has been an important doctrine of international law, which has gained importance in the light of growing acts of illegal use of force threatening world peace and security. Article 51 of the United Charter stated, "Nothing in the present charter shall impair the inherent right of individual of collective self-defense if an armed attack occurs against a member of United Nations, and this means it provides for the right of country to engage in self-defense, including collective self-defense as well as against armed attack." Next, humanitarian intervention is also known as responsibility to protect, which is a doctrine of international community to help protect the world population. It is a lawful ground for a state to use force in other territory in order to protect the human rights of individuals. However, there is cases like the human suffering in the Syrian crisis, which began February 2011. It is a tragedy for the Syrian people, but also demonstrably a crisis of international intervention. The international community has failed to protect and assist civilians. They should do a better defense for people than just intervene without saving those innocent civilians.
Here I'm gonna explain you a little bit about the international humanitarian law. What is international humanitarian law, or we can call it as IHL? This is can be generally defined as the body of international law governing the conduct of armed conflict. International humanitarian law is a set of rules which seek for humanitarian reasons to limit the effects of armed conflict. It protects persons who are not or are no longer participating in the hostilities and restricts the means of and methods of warfare. International humanitarian law is also known as the law of war or the law of armed conflict. International humanitarian law is part of international law, which is the body of rules governing relations between states. And the last one, I'm gonna explain you a little bit about the principle of IHL. The person who are not or no longer taking part in hostility shall be respected, protected, and treated humanly. They shall be given appropriate care without any discrimination. Second one, captured combatants and the other person whose freedom has been restricted shall be treated humanly. They shall be protected against all acts of violence, in particular against torture. If put on a trial, they shall enjoy the fundamental guarantees of a regular judicial procedure. The third one, the right of parties to an armed conflict to choose methods of or means of warfare is not unlimited. No superfluous injury or unnecessary suffering shall be inflicted. The last one is, in order to spare the civilian population, armed force shall at all times distinguish between the civilian population and civilian objects on the one hand and military objective on the other. Neither the civilian population as such nor individual civilians or civilian objects shall be the target of military attack. But sadly, there are countless examples of violation of international humanitarian law. Increasingly, the victims of war are civilians. However, there are important cases where international humanitarian law has made a difference in protecting civilians, prisoners, the sick, and the wounded, and in restricting the use of barbaric weapons. Given that this body of law applies during times of extreme violence, implementing the law will always be a matter of great difficulty. That said, striving for effective compliance remains as urgent as ever.